Good morning, everyone. So, today we will have some basic knowledge about what is evidence law and what does Indian Evidence Act contains and teaches us. So, without wasting any time, let's start with it. With the first question, that is, necessity rule as to the admissibility of evidence is applicable when the maker of a statement is dash. Select the correct options from below. The options are A, is dead or has become incapable of giving evidence. B, is a person who can be found but his attendance cannot be procured without unreasonable delay or expenses. C, is a person who cannot be found, or D, all of the above. The correct answer to this question is option D, that is, all of the above statements are correct. That means to say, necessity rule as to the admissibility of evidence is applicable when the maker of a statement is dead or has become incapable of giving evidence, can be found but his attendance cannot be procured without unreasonable delay or expenses, or is a person who cannot be found. Moving on to the next question, that is, under section 32 of the Evidence Act, a statement of a person who is dead to be admissible, what must happen? The options are A, it must relate to the cause of his own death. B, it may relate to the cause of someone else's death. C, may relate to the cause of his own death or someone else's death. Or D, both B and C are correct. The correct answer to this question is option A. That means to say, under section 32 of the Evidence Act, a statement of a person who is dead to be admissible must relate to the cause of his own death. So section 32 deals with dying declaration. It means that a person, if dying and if made a declaration or anything in front of police or a magistrate as to who was responsible for his or her death, then his declaration is admissible in court and is taken to be of the utmost importance. Under the section 32, a dying declaration can act as a sole evidence or a basis on which the conviction can be based. This is because this section is believed to be made on the backbone that the dying person does not meet its maker or by having a false or a lie on his tongue. So as a result, it is presumed that if a dying person is making any declaration about a confession or a person who is responsible for his death, then it is taken to be utmost important and as a correct information by the person who is going to die. So for attracting section 32 of the Evidence Act, there should be three things or the three ingredients that has to be fulfilled, which are: first, a person should be on a deathbed first. Second, there will be reasonable chances of his dying. And third, the death must accrue on immediately or after some time. So if these three ingredients are fulfilled, then section 32 of the Evidence Act is attracted and the statement made under section 32 is taken as a prima facie evidence and can lead to conviction of any person. So after that, let's move on to the next question, which is: a person whose statement is admitted under section 32 of the Evidence Act must dash. The options are: A, must be competent to testify. B, need not be competent to testify. C, may or may not be competent to testify. Or D, only A is correct and B and C are incorrect. The correct answer to this question is option C. That is, a person whose statement is admitted under section 32 of the Evidence Act may or may not be competent to testify. Let's move on to the next question. A dying declaration is admissible in which of the following proceedings? The options are: A, only in criminal proceeding. B, only in civil proceeding. C, in civil as well as criminal proceeding both. And D, in criminal proceeding alone and not in civil proceedings. The correct answer to this question is option C, that is a dying declaration is admissible in civil as well as a criminal proceedings both. The next question is a dying declaration can be dash. Fill in the blanks with the correct options. The options are A, can form the sole basis of conviction without any corroboration and independent evidence. B, can form the basis of conviction only on the corroboration of independent witness. Cannot form the sole basis of the conviction unless corroborated by independent witness. Or D, only B and C are correct. The correct answer to this question is option A, that is a dying declaration can form a sole basis of conviction without any corroboration of the independent evidence. Again, as discussed before, a dying declaration is taken of the utmost importance of the presumption that a dying person wouldn't meet his maker by having a lie on his tongue. So for that matter, if any dying person is or gives a statement, then it is of the utmost importance and is presumed to be true, and by that can form the sole basis of conviction without any corroboration by the independent witness. The next question is, a dying declaration should be admissible. What should happen? The options are A, it must be made before a magistrate. B, it must be made before the police officer. C, it may be made before a doctor or a private person. Or D, may be made either before a magistrate or a police officer or a doctor or a private person. The correct answer to this question is option D, that is a dying declaration to be admissible may be made either before a magistrate or a police officer or a doctor or a private person. Moving on to the next question, which is declaration in course of business are admissible under which of the following sections? The options are A, under section 32 clause 1 of the Evidence Act. B, under section 32 clause 2 of the Evidence Act. C, under section 32 clause 4 of the Evidence Act. And D, under section 32 clause 7 of the Evidence Act. The correct answer to this question is option B, that a declaration in course of business are admissible under section 32 clause 2 of Evidence Act. Let's move on to the next question, which is declaration as a custom are admissible under which of the following clauses? The options are A, under section 32 clause 1 of the Evidence Act. B, under section 32 clause 2 of the Evidence Act. C, under section 32 clause 4 of the Evidence Act. Or D, under section 32 clause 7 of the Evidence Act. The correct answer to this question is option C, that is under the section 32 clause 4 of the Evidence Act, declaration as to the custom are admissible. The next question is, under section 32 clause 4 of the Evidence Act, the declaration must be dash. The options are A, as to the public rights and customs are admissible. B, as a private right and customs are admissible. C, as to both public and private rights and customs are admissible. Or D, only as a custom are admissible. The correct answer to this question is option A, that is as to the public rights and customs are admissible. The next question is, opinion of the expert are relevant under which of the following sections? The options are A, under section 45 of the Evidence Act. B, under section 46 of the Evidence Act. C, under section 47 of the Evidence Act. Or D, under section 48 of the Evidence Act. The correct answer to this question is option E, that is, opinion of the experts are relevant under section 45 of the Evidence Act. So let us now see what does section 45 states. Section 45 states opinion of the experts. It states that when a court has to form an opinion upon a point of foreign law or of science or art, or has to identity of the handwriting or fingers impressions, the opinion upon that point of person specially skilled in such foreign law, science or art, or in question as to the identity of the handwriting or the finger impressions are relevant facts. Such persons are called experts. So section 45 deals with the opinion of the expert. This section means that whenever a court has to clarify its understanding on some out of basic things like foreign law, science and art, or the identity of the handwriting or finger impression, the person who are expert in these types of knowledge are called by the court for their assistance, and they are known as experts. Moving on to the next question, which is under section 45 of the Evidence Act, the opinion of the expert can be for which of the following? The options are A. Identity of the handwriting, B. Identity of the finger impression, C. Both A and B, and D. Neither A nor B. The correct answer to this question is option C, that is for identity of the handwriting and the identity of the finger impression, the opinion of the experts can be called under section 45 of the Evidence Act. Moving on to the next question, that is under section 45 of the Evidence Act, the opinion of the expert can be the question of what? The options are A. Indian law, B. Foreign law, C. Both A and B, or D. Only A and not B. The correct answer to this question is option B, that is under section 45 of the Evidence Act, the opinion of the expert can be the question of the foreign law. Moving on to the next question, that is opinion of an expert under section 45 of the Evidence Act is what type of proof? The options are A. It is a conclusive proof, B. It is not a conclusive proof, C. It is a supportive and corroborative in nature, or D. Either A or C. The correct answer to this question is option C, that is, in the opinion of the expert under section 45 of the Evidence Act is supportive and corroborative in nature. Moving on to the next question, that is a disputed handwriting can be proved by what means? The options are A. By calling an expert, B. By examining a person acquainted with handwriting of the writer of the question documents, by comparison of the two admitted and disputed handwriting, or D. All of the above. The correct answer to this question is option D, that is all the above are correct. That means to say a disputed handwriting can be proved by calling an expert or by examining a person acquainted with the handwritings of the writer of the question documents, or by comparison of the two admitted and disputed handwritings. The next question is, or the last question is, the res inter alia acta is receivable under which of the following sections? The options are A. Under section 45 of the Evidence Act, B. Under section 46 of the Evidence Act, C. Section 47 of the Evidence Act, or D. Under section 48 of the Evidence Act. The correct answer to this question is option B, that is the res inter alia acta is receivable under section 46 of the Evidence Act. So now let us understand what is section 46. The section 46 deals with the facts bearing upon the opinions of the expert. This section states that facts not otherwise relevant are relevant if they support or are inconsistent with the opinions of the expert when such opinions are relevant. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.